Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. My co-host, once again, the wonderful Jesse Barrientos.
Oh, thank you, Dave. I'm doing really good. How about yourself?
I'm doing well. Good to see you.
You as well.
Well, Jesse, it's real estate time once again.
Well,
there's a peak season.
There is,
but it is
in the
always
spring.
an evergreen because people always either have to move or divorce or job location transfer. So real estate is always a constant, but there are peak seasons. And I think at the time this airs, it will be very close to that peak season. So let's get right into real estate.
Okay, well,
What is the most important thing that we need to know about a real estate transaction? What's the most important piece of evidence or information?
Well, I think the most important thing is to make sure you have a good attorney, a real estate attorney, somebody who knows what he or she is doing. And, you know, it really depends on whether or not you're buying or you're selling. But in either circumstance, the first thing that you really start out with is your listing agreement with your realtor, which, you know, there's a lot of realtors out there, there's a lot of attorneys out there. You can negotiate what that percentage is. Generally, it's 6% of the total purchase price. However, you can also, you know, if you negotiate it, you can get down to 5% or so. I mean, hey, you know, 1% on $300,000 is going to save you, save you some bucks.
Yeah, I think 5% is becoming more and more common in the industry. You also want a realtor who knows that specific area. So if you're looking in Bloomingdale and the real estate attorney is up in Waukegan, you might want to think twice about that. You want someone who knows that general area that you're looking in.
That's true. I mean, you know, you could certainly have somebody who's in Waukegan that knows about Bloomingdale. But hey, you just like anybody these days, you can go on and do a search and find out. But the whole idea of having somebody who is familiar with that specific area is so that your place will sell.
Okay, let's talk about the sale. Once you have a buyer ready, willing, and able to buy your property, or if you're willing to buy someone else's property, we're going to need a contract.
Yes, you are.
And that has become very standardized in the area. Is that correct?
That is. And they have the Association of Realtors contracts. We have a couple of them here. They keep on revising them because just like anything happens, there's a need to adjust things as things go on because, and we'll talk about it, I mean, at the attorney review provision, people ask about certain things and it goes on there. But you have a contract that is about 13 pages long and the font is pretty small, but the things that go in a contract are the real estate contract are things that would go in a regular contract. Okay, who's the buyer? Who are the sellers? What's the identification of the property? Not just the street address too, but also the PIN number, right?
Property index
the property index number, right?
For purpose of real estate tax.
Exactly right. The purchase price, obviously, very important part of that too. And then anything else that goes with the property, personal property, for example. Garage door openers, any drapes or
built-in
dishwasher,
gas grill, outdoor furniture,
right. Could
drapes,
be right. The
ceiling fans,
refrigerator and freezer, and those kinds of things.
You want the house and whatever else it's coming with.
Right, exactly, and it needs to
itemized
be specified.
In the contract.
Exactly right.
Including a sump pump and things like that you wouldn't even think about having to put in. You want to make sure they're in.
You absolutely do. And what you're also going to do too is, and again, like I said, it's different. You have to have a contract either way, buyer or seller. But there's a little bit of different approach if you're the seller or if you're the buyer. And one thing to talk about is the earnest money, and that's just kind of letting the other person know. So if you're the buyer and you put a bid in for this particular property, hey, I want you to know I'm serious. So if we have a $5,000 earnest money, hey, you know what? That tells you a little bit more serious than not.
Let's talk about that. That's paragraph 4.
Yep.
It talks about an initial earnest money deposit,
right.
which is what you would submit with your offer.
That's correct.
And then upon acceptance, that can kick up to a much higher amount.
It sure can. But generally what I've seen, it's just, usually just the initial one. Depends on how badly you want the property. For example, if I'm a seller and there are 3 buyers and one person has to get a loan, one person is going to pay for it with cash, or one person is going to do, half of one and half with the loan, half cash and half with the loan. Well, who do you think I'm probably going to, want to accept? Probably the person
all-cash buyer.
with the all-cash buyer, because then you don't have all those other issues that could come up with everything else. It's a strong, solid buyer. And if somebody puts down a significant amount of earnest money, then that tells you, hey, this person is serious. They're not just kind of messing around here.
Okay. So the realtors are going to submit the offer back and forth amongst themselves, talk to their clients. Let's say we get an agreement on price. Let's just call it $200,000 is
Sure.
the purchase price. Do we have a deal?
Well, there's a whole lot of other things that have to happen. So once your real estate agent will help you with the documents and the contract that need to be completed, and then it will be submitted.
But they cannot give you legal advice.
They cannot, because they're not they're not an attorney.
Right.
If they were an attorney, hey, that might be a difference. I've done where there's no realtors involved situations where, hey, it's the contract, but obviously can only advise your specific client. Generally what happens is the realtor will complete it, they'll submit it to the other side, the other realtor, they'll give it to the sellers. The sellers will look at it, and of course they're looking for price. Generally that's what usually goes back and forth a lot of the times, and they'll say, no, hey, our listing price, Dave, was $250, so you know what, you submitted $200,000, yeah, no, okay. So they might go back and forth a little bit on that. However, let's just say, for the sake of the argument, right, that we're at I want to sell it, hey, we're at $230, okay, and then the sellers accept it. The date of acceptance is a very important date, because that's when that triggers some of the other provisions in the contract.
So it's very time sensitive.
It's very time sensitive. There's a lot of deadlines as it relates to real estate, and it's very important that you stay on top of those deadlines, because if you don't and you blow the time, then you're going to be stuck.
Okay, let's talk about the most important deadline, and that pertains to the attorney review.
Right, the attorney review and inspection. Generally, they go together, and so within 5 business days from the date of acceptance, again, business days. So if
Friday night contract, let's call it.
or even
Friday night
if you did it Saturday, okay, well, 5 business days isn't right. So if you did a Friday night, then hey, 5 business days doesn't start till Monday, Tuesday, Wednesday, Thursday, Friday, right?
So in essence, you have a week in that circumstance.
You do, again, because it's business time, and I mean, you really, if you're a buyer, you want to already have all of your ducks in a row. Now, a lot of realtors have resources and have people that they'll refer folks to, for example, inspectors, but you don't have to use whom your real estate agent tells you. I mean, you should have a good relationship with your real estate agent, and you should be able to trust them.
Right.
And so you want to do that inspection. You want to have everything set, so when there's a date of acceptance, hey, boom, you want that person to go out there and inspect it.
Okay, let's break down these 2 items, because
Sure.
they're different. Start with the attorney review.
The attorney review.
What does that mean? How does it work? What can the homeowners expect?
Well, either attorney can approve the contract, reject the contract, but it can't be rejected solely on the basis of the purchase price. And then they can make modifications to the contract, again, anything except really purchase price. And the contracts have a form in there. Hey, we can go right to it. And I believe it's paragraph 11 is the attorney review, if I'm not mistaken. And it is. So we've got approval, disapproval of the contract, not based on the purchase price, proposed modifications, except for the purchase price, okay, that would act as a counteroffer. Now, a counteroffer, if you tell me, hey, I want these modifications to the contract, that's a counteroffer. You need to specify what it is. But the contract, and again, that's why we have standard contracts, does a really good job in indicating what you do. You have to indicate under which provision it is, 11A, B, C, or D. And if it's not, it defaults to paragraphs, or rather C, which basically means that it's not a counter offer. Okay, so that's what you do.
But once these items are put in, the attorney has sent the letter requesting modifications or
Right.
whatnot, that's going to toll or extend the time period. As
Right.
long as it's in there within the 5 days, now it can drag on for several weeks before the contract is either accepted or ultimately reject it.
Well, the contract's already been accepted, so what we're dealing with now
Not
are,
approved.
well, right, we're dealing with those terms, the modification requests. And recently I had one with, somebody made, heck, it was, I think, a 5 or 6 page modification request wanting to change all different kinds of terms. And the reason why they put these terms in the contract, as I mentioned before, is because based upon experience, hey, listen, these are the things that need to happen. We have new regulations after everything tanked with real estate. There's different things for lenders, lender requirements and everything else. There's an intent to proceed letter and different kinds of things. And so they're trying to change the terms of the contract. You don't have to do that. And realistically, depending upon which provision of the attorney review they're doing it, you could, so if you sent it to me and it was under a provision that kind of that made it a counteroffer, I could tell you, you know what, we reject it and that's it. You get your earnest money back though, for sure, and that's it. That's the end of the deal. However, hey, a seller wants to sell, the real estate buyer generally wants to buy it, and so you negotiate those things. Now, let's turn our attention, Dave. I know you know a little bit about that too, and that's the inspection provisions. What do you think they search for in the inspection?
Well, it depends on your inspector. There's aggressive inspectors that have killed a lot of deals, and there's other inspectors that are a little bit more reasonable, and they're just going to make sure that the main items are disclosed if they're defective,
Mm-hmm.
and then some of the other items, they're going to mention it too, but they're not going to dissuade you from purchasing the home. They might be able to work some kind of deal where the seller actually contributes a certain financial amount so that either you can repair those items or you can insist that the seller repair those items. So we're looking at big items, in my opinion, for an inspector. If you really want this property, what would prevent you from going ahead with this deal? Is it major? If it's minor, we might be able to work it out.
Right, and anything, so that you know, under the inspection provision, anything that works for the purpose for which it was intended, it works. It doesn't matter if the furnace is, 20 years old. If it works, it works, okay? So that's not really subject to that.
Right.
You have other things. Now, obviously, an inspector can't pull up the carpet. They can't pull back the drywall, okay, and look at those different kinds of things. And really, I don't know if it's an inspector that kills the deal, but hey, they bring things to light, and either people want to go ahead with it or they don't. They want to, and nowadays, what you get is really a closing cost kind of credit.
Well,
That's
if they see structural issues,
structural issues,
if
right?
they see mold that hasn't been remediated, if they see major things like that, health concern.
Oh, that's going to be a deal killer.
Yes.
Because as a purchaser, even though no two pieces of real estate are the same, as a purchaser, you don't want to go there. There's plenty of other places really, that you can buy. But you're going to go through that period of time, and either, like you said, the seller's going to agree to either repair it. And what I usually do when I'm on the buying side and we request those things, we don't want the homeowner to go in there and repair it himself. We want it done by a licensed, insured, and bonded electrician or contractor, or somebody who knows what they're doing. We don't want the homeowner to go in there and tinker with the electric. I changed the polarity. Want somebody who knows kind of what they're doing, and then you're going to want receipts.
Oh,
for those
also
things.
an additional warranty might be nice, that the work that they did is going to be good for 90 days or 6 months, even a year.
That's transferable.
Okay, right.
So that you have that. So assuming you're past that, but I think before we even go to that part, there's a couple more elements to the contract, to the paperwork that we need to talk about. So, and that goes along with the whole deal. One of those things, the Illinois Residential Real Estate Disclosure Report, and that basically tells you, hey, whether or not there's been any whether or not the seller's occupied the property within the last 12 months. It's asking if there's any leakage problems or is it located in a floodplain. There's a whole bunch of things that it asks, and there's 3 check boxes. Either that yes, or no, or it's not applicable. Right. Okay, fireplace. Okay, well, no, there's no fireplace, so it's not applicable. And that gets signed by both parties, and it's very important for a seller to disclose those things. Now, part of the law says that if there was something, let's say there was some type of leakage that you did remediate, okay, that you don't have to disclose it. I am of the opinion that you should, because you know what? You're going to set yourself up. I've done real estate litigation for that exact thing on actually a couple of different occasions. And so you don't want it to come back to bite you. You want to be honest. Say, look, this is what happened, but it was remediated. Here you go, if you have the stuff. But since that time, we've had no water. The real estate agents will probably tell you, hey, you don't have to disclose it.
Right.
Because they want to make a sale. They want to help you sell your home too, And then there is also, in addition to that, there is the lead-based paint disclosure, and that's only applicable for houses built prior to 1978, Dave.
That's right.
Right? And so, lead paint used to be a big thing, and hey, if you have children or pets, that's not going to be good. Kids put stuff in their mouth, and so do pets all the time. So that's a disclosure. And then also you have radon.
Yeah, let's talk about radon, because a lot of people don't understand what that is. What is radon?
Radon is a naturally occurring gas that could be a carcinogen. And generally it's in the basement. And so they do have tests for that. But the area has to be done under the appropriate circumstances, or it's not going to be accurate. So that means, people can't be going in and out. It has to be done. I don't know. I thought it was for 24 hours or something like that. I've had a couple situations where there has been radon, but there is also radon abatement procedures that can happen. That and I represented the sellers on one of those cases where they had an abatement place come in and take care of it. Now, if it's in a basement and you're going to make that in a family room and your kids are going to play down there, you don't want to have that kind of an issue. So that's something that's important to do as well.
Yeah, there's ways to exhaust it out of the house.
Right. That's with radiation.
Piping.
Right.
Okay.
If you live in a condo on the 8th, 9th, 10th, 12th floor, you don't have to worry about radon. Okay. Then you have the mold disclosure, which is very important. They didn't used to have those kinds of things, but there's a lot of litigation concerning mold, and it could be very, very harmful and detrimental for a lot of people. Some people are more sensitive to that.
A lot of the things in these agreements, in these disclosures, is to prevent litigation, in a sense.
Right.
Let me give you an example. In the new contract here, and this is something new, a seller has to disclose that if they made an improvement to the property, that they in fact have paid the village the permit fee.
Right.
Because they don't want the buyer to be able to come back, purchase the property rather, and then the village comes in and comes after the buyer for the failure to get the permit. So they want that disclosed up front.
Right. It's not even just the payment of the permit, because if somebody builds a garage and they didn't have a permit, it's an illegal structure. They can force you to take it down.
Right.
And that happens a lot. People just do what they want to do, even if it's a sound structure. Okay, so yeah, that's very important too.
Yeah. That's why we're up to 13 pages in a contract, not including the disclosures. Yeah. I think in about 50 years, you're looking at a 50-page document.
It very well may be for that, because there's different things that happen for different circumstances, and so the contract is really evolving, and it's meant to kind of prevent the attorney not approval, but doing those modifications. If everything's in the contract, then you really have it. And a lot of the terms, they are sufficient and fair for what's going on. A lot of people try to change things to suit their needs. Again, if you're the purchaser, you want to change certain things, and if you're the buyer, you don't.
Okay. Something important that we need to bring up too. We talked about this being a cash deal, where they have the money, they don't need a mortgage. Most deals are not of that variety. So let's talk about the mortgage contingency clause and how that works.
The mortgage contingency clause, basically you have to get a mortgage. And there's also an intent to proceed letter, which has to be given in a certain amount of time. A lot of attorneys, sellers, attorneys, they want to get rid of that because, they don't want to, get it from the lender. It's no big deal, really. It's essentially that, hey, listen, I intend to proceed with this loan. I applied for this loan. There you go.
Well, you want a pre-approval letter.
Well, if you have, that would help you if you're buying something, because again, as a seller, I'm going to look at it. Hey, if you're already pre-approved, then I don't have to wait here and think and wonder whether or not you're going to be. Okay, to waste my time, especially if there's other people that are interested in the real estate. In the property. So the mortgage contingency allows you a certain amount of time within which you have to have a commitment, unconditional commitment from the lender to be able to purchase the property. A lot of times it doesn't happen, and that's okay. as long as your attorney, if you're the buyer, sends a request to extend that time. If there's no extension request, then you're out of luck. Then you're stuck with it, whether or not you get the loan. And so, at the very least, you're going to lose your earnest money for that to happen. So that's why, again, everything is very deadline and time sensitive in that equation.
Okay.
Some of the other things that I think maybe want to talk about.
Yeah, I want to talk about tax prorations because a lot of people, when they're purchasing a home, they're looking at the purchase price, but they're not really factoring in what the total cost is going to be when they factor in what the real estate tax is, the insurance, the utilities. It's a lot more than just the purchase price.
Right.
So certain homes have a hard time selling because the real estate taxes may be excessive. So let's talk about the prorations, the tax prorations that are provided for in the contract. How does it work and what does it mean?
Well, real estate taxes are paid in arrears 2 times a year, and by arrears. So in other words, the taxes I'm paying now, and I think in August was the second installment, if I'm not mistaken, the taxes you paid were for last year. And what have we learned about taxes, Dave? Do they go down?
Typically not.
Typically not. Where do they go up? And so generally, the seller wants the prorations to be 100%. The buyer wants them to be 110%. A lot of times, depending upon the area where the real estate is, it's 105% because the taxes are going to go up and you are paying in arrears. So what happens is the buyers get a credit. And so you take the most recent ascertainable tax bill and you do your math and at 105% if that's the agreement, right, and the contract. So they get a credit for that because, again, the taxes aren't due yet. You pay them in arrears.
So it's based on the number of days that you're going to get the credit for.
Right up to and through the closing. That's absolutely correct. But also there's other things to look at, too. And there are disclosures in the contract that the parties sign. For example, okay, so here are the taxes, Dave. It looks pretty good. It's only a couple $1,000. Okay, but Dave, you have a senior exemption. Okay, I'm not as old as you, so I'm not going to get that senior exemption. So that's important for the parties to negotiate and to know because, again, hey, guess what? All of a sudden now, they're going to go way up there because you've had that senior exemption or whatever exemptions that there may be available that I might not, as a buyer, be entitled to. And that's why you need an attorney who knows real estate.
Let's talk about something else that will possibly terminate a deal, even though both parties want the deal to go forward, and that's the appraisal.
Well, and that's from your lender. The lender will send out an appraiser. A lot of times they don't necessarily go in. It just depends on who the lender is.
What are they trying to make sure of? What's the point of the appraisal from the lender's
The point of the
standpoint?
appraisal is that the money they're lending to you doesn't exceed the value of the property. So basically, let's say that the value of the property is $100,000, and you're wanting to lend $200,000 to buy it. It's not going to work.
Well, isn't the value what a buyer's willing to pay for it?
It is, but they do market analysis. Basically what they do is they compare the history of the home. They compare other homes within about a mile and a half radius, and the square footage, the stature, and everything else. And that's how they come up. That's just the analysis. They have other more detailed appraisers or appraisals that come in, and they come in and they look at everything, and that's a little bit different.
Okay, so what will happen if the lender appraises the property and it doesn't appraise out to the value it should?
Well, then you're not going to get the loan, and so you have the mortgage contingency. The mortgage contingency, the whole purpose of that paragraph is it gives you an out. If it doesn't appraise for the amount of it, then you can get out of the contract.
Well, man, wait a minute. Can't you put more down on the house so that you can lower the amount of the loan?
You could, however, if the house isn't worth what I'm paying for it, then...
Okay. Well, the seller can always reduce the price as well to get it sold.
The seller could do that. They could have that kind of an agreement.
Because they're going to have the same problem when the next buyer comes in.
Maybe.
If they hold out for that price.
Yeah, true.
Depends on the lender,
True, maybe,
correct?
right. Depends on the lender. So, because sometimes, the appraisal will be, okay, hey, what's the cost of the property? Okay, there you go. Here we are. Because we want to do business. That's not a good way to do it, but, that does happen. So, that's part of the problem, that could happen. So,
Okay. What other paragraphs are really important? We got a few minutes left, Jesse.
Okay, we talked about the prorations. That's really important. The homeowner's insurance, you have to get your own insurance. It's important that you do that for the lender, because the lender in your paperwork, they'll tell you, if you don't get insurance, okay, we're going to provide it for you. And I guarantee you that the insurance they're going to provide is going to be a whole lot more expensive than what you're going to be able to get.
Force-placed insurance is
For the
always
place
much
insurance.
more expensive.
The other thing is that if it's a house, okay, not a condo, there's going to be a survey. It's going to be staked, so you could see the boundaries of your real estate, which is really nice. It gives you an idea on what it is and to make sure what it is. In fact, this requires the seller to procure that, and it has to be within the last 6 months. And so the buyer's attorney is going to look at it and make sure, hey, look, there's nothing encroaching over like a fence. Maybe the fence on your property is over the line. Okay, well then the title insurance company has to insure over. I'm also a title agent for a couple of title insurance companies, and so that's the whole purpose of the title insurance as well, because you want to make sure as a buyer, hey, look, I want clear title. So what they do is they search the history of the property so that, hey, you're conveying exactly what you're getting, lock, stock, and barrel.
Okay. Let's talk about the closing date. I know it's in the contract. A lot of people think it's written in stone, but in actuality, it's very flexible, is it not?
It is flexible, because if you have the issue with the mortgage contingency date, that might push back the closing date. If the lender doesn't have all the things that they need from the title company, or they want to make changes, that could delay that as well too.
Okay. Let's talk about the big complication when someone needs to sell their house before they can buy your house.
And there is a contingency in here for that too, that, hey, the contract is contingent upon you selling your house to make this happen. So if that deal falls through, then you get off the hook here.
Okay.
The other thing I think that people need to know too, when you're talking about the expenses, not only the title costs and what you're paying your realtor and what you're paying your attorney, is also there are state and municipal and county taxes that you have to pay.
Wow, the tax
on the
man is
sale.
everywhere, isn't
It
he?
is everywhere. In Chicago, it's everybody gets.
They call it stamps,
gets
so
bite.
that's a little softer
Yeah, tax
for you.
stamps, right? And it's based upon so much per $1,000 of the contract. And again, those things have to happen. If you're in Chicago, for example, there has to be a water certification. And by the way, I know we don't have a lot of time. I've had there's other contracts for for example, like if you want to convey a parking spot and you own a parking spot, maybe you have a couple parking spots, and you own, you want to get rid of one. So there's actually, you got to get a water cert. It costs $50 from the city of Chicago for your parking spot. You have to do that. No fountain in the parking spot.
Makes no sense.
Okay, but if you do it, if you're selling a parking spot with your condo unit, I mean, that all goes together because you get the water cert. But if you're doing something individually like that, they also, have you on that. The bottom line is, hey, look, you know what? You need to know what you're doing, and the only way you're going to need to know what you're doing is by surrounding yourself with competent professionals.
Right. And as great as your information is today, they're not going to learn it all from this
No.
broadcast. So they really need to get a team together, which is a competent, great realtor, a great attorney, and then the rest will fall into place if you have the right team behind you, so that you don't get into trouble and pitfalls, and you want to avoid that kind of stuff.
Right. You want somebody who's going to explain everything to you every step of the way.
Okay.
So
Well, Jesse, thank you very
that's
much.
important. You bet, Dave.
Great information on real estate. If you're buying or selling, make sure you got your team together. We'll see you next time on Legal Action. Take care.